Hi, folks, and welcome to this webinar. I'm Will Gillis, Executive Director of the Fully Informed Jury Association, and with us today we have Robert Anthony Peters, President of our Board of Directors. FIJA has been working to educate people on the rights of jurors since 1989. We've gotten legislation passed and helped thousands of activists distribute enormous amounts of educational materials. Today, there's so many people spreading FIJA literature that some Republicans in Congress have pushed a bill to cut all federal funding or contracts for anyone involved in educating one on one's rights as a juror. This would potentially affect anyone from a small business owner who takes a small maintenance contract to a teacher or professor in a school or university, although it would not impact FIJA or most jury nullification activists who exercise basic First Amendment rights. Today, I'm going to talk a little bit about how to be such an activist, and how to go about distributing information on jury nullification, some risks, some best practices, some advice. But first, what are these rights, and what is jury nullification? To give an overview and some history, I want to turn things over to Robert.
Thank you, Will, and thanks for all the great work you're doing for FIJA and for the cause of jury nullification. And I'm really grateful to everybody who showed up and is interested in learning more about jury nullification. And feel free to type in questions in the chat, and we'll try to wrangle those as best we can. We'd like this to be as useful as possible for you. And so if there's things you want us to expand on more or questions that you have, feel free to shoot those. But some of you've all heard the phrase jury nullification. But what is jury nullification? Well, in sort of its strictest sense, jury nullification is when a jury returns a not guilty verdict, even though the jurors believe that the defendant has broken the law. Because the not guilty verdict can't be overturned, and because the jurors cannot be punished for their verdict, the law is said to be nullified in that particular case. So, quite often you'll hear judges explain to the jury in their instructions, right? Your job is to decide the facts of the case, and I will decide the matters of the law, and they will interpret it for you. And what jury nullification says is that no, this is a right that you, as members of the jury, have to decide not only the facts and determine what actually occurred, but also the justice of the entire proceedings. If the law is moral, is constitutional, is something that should be upheld, would serve justice's interest, if that law is being applied correctly in this circumstance, and if a guilty verdict would ensure that a just outcome occurs from that trial, that the punishment is measurable to the offense. And there's any number of ways. I mean, this is just kind of a handful of ways by which you as a juror might interpret the situation. And sometimes it's easier to think of jury nullification in some of its alternate phrases: a conscientious acquittal, a juror's pardon, veto power, a jury veto. So these are all kind of different ways to wrap your head around this concept. But really what it boils down to is it's incumbent on you. You have the right to decide based on your conscience what a just outcome would be. And so it's a very important responsibility that we have to our fellow man, and one that's been with us for quite a while. So I do want to outline, what the history of jury nullification is. So you say, oh, this isn't, just something that a couple of bearded guys on a Zoom call came up with, that this is a real historical right that is enshrined in English and American custom. And Will may talk about it, but it's seems under even greater threat in the United Kingdom currently than in the U.S. But we'll talk a little bit about that. Right to a trial by jury has been an important part of the common law tradition since even before Magna Carta of 1215. It was really enshrined when the lords were negotiating with the king, and they said, "Look, we want jury trials, trials by our peers." But this seems to be something that even harkens back to Anglo-Norman traditions, even before Anglo-Saxon traditions before the Norman invasion. And it's really interesting to see kind of some of these other traditions around the world that have similar practices. But because of where the U.S. Gets its legal system from, we it's really significant for us to focus on the English tradition. And so the levelers would be um, they were a radical rights-based group that was part of participants in the English Civil War. And there was one member of the levelers named John Lilburne in particular, who was a really fascinating character. He would basically he'd upset the king. The king would throw him in the Tower of London, and then they would bring him to trial. And the jury kept finding him not guilty, even when the facts seemed to contradict him. And so Lilburne had written at that time that the jury by law are not only judges of fact, but of law also. And you that call yourselves judges of the law are no more but Norman intruders. And indeed and in truth, if the jury please, are no more but ciphers to pronounce their verdict. And so he was laying a very strong claim that was part of the cultural milieu, the feeling of how the kind of power that jurors had at that time. And this was something that was commonly understood and felt, but as always, we need to remind ourselves of those rights we have periodically. During the 1400s, 1500s, the jurors, so many crimes at that time were capital crimes. In other words, you would be executed for them. And so the jury would often either find people not guilty or reinterpret what happened so that they became lesser crimes. Not that the jurors wanted society run amok, by no means. But they also understood that it's important that there be that justice be a consideration in the justice system, that the punishment should fit the crime. And stealing an apple, though a capital crime, likely doesn't merit being killed by the state for that. And so they've always been an important safeguard against government overreach. One of the biggest events to really solidify the notion of jury nullification in the English common law tradition was a decision that revolved around someone whom you may be familiar with, William Penn, our very own of Pennsylvania. He had been a preacher in the United Kingdom at that time, and along with his Quaker brethren, were attempting to practice their religion, even though it was not allowed as Anglicanism. The Church of England was strictly enforced. That was the rule at the time. And so they got in trouble for many of the things that were enshrined in our First Amendment. They didn't have the freedom to assemble. They didn't have the freedom of their religion. And so they were charged with crimes along those lines, factually guilty. And the jury came back and said not guilty. Well, the judges of that trial said, that's not the correct verdict. We're going to have to send you back to reach the correct verdict. And so the jury left, and then they came back and they had the same not guilty verdict. The judges sent them out again, and they returned again. Similar situation. So they send them out again. And after 3 times or so, the judge finally says, okay, you all will be locked up until you come up with the appropriate decision. And then finally, a higher court intervened and said, you cannot compel a decision. The jury has autonomy in what they can decide. Um, and there was a very brave individual, Ed Bushell, who was the foreman of the jury, who kind of took the brunt of this, but they stuck by their conscience and held that line there. The first example of it in the colonies was the case of John Peter Zanger, a name that you may be familiar with as well. This was in the 1730s when he had published some in print a story about corruption of the New York governor. Now, the at that time, it was libelous to say anything that was against the government. It didn't matter if it was true or not. Libel was only considered something that the government wouldn't like. And so they charged Zanger again. Factually, they had him dead to rights, and the jury found him not guilty. And this was an important for our cause. And this has really helped enshrine this notion that this would be a major part of what was soon to be these United States. From there, we start seeing a shift. Well, I should say early on, just after the Revolution, there was a strong notion. You had Supreme Court justices who were speaking fondly of jury nullification and of the rights of jurors. And the notion of trial by jury was considered incredibly significant. I mean, it was mentioned in the Declaration of Independence. It was mentioned in the Constitution, and of course, the Bill of Rights, the amendments to the Constitution, that you have a right to trial by jury. So clearly, they felt that was important. But I want to read you a brief quote from John Jay, the first Chief Justice. This was in Georgia versus Brailsford. This is something that he had to say, that he wrote in his decision. It is presumed that the juries are the best judges of facts. It is, on the other hand, presumed that the courts are the best judges of law. It's typical of what we hear, right? But he goes on, but still, both objects are within your power of decision. You have a right to take upon yourselves to judge of both and to determine the law as well as the fact in controversy. And this is a incredibly powerful comment by the first Supreme Court justice. And obviously, jury nullification was a part of the founding of the United States. Well, then we enter in a tough period in the 1800s where you have slavery becoming a more divisive issue. You have, in particular, the Fugitive Slave Law, which binds everyone and anyone to assist in the capture and return of escaped slaves. Fortunately, there was a number of people who felt that slavery was wrong and wanted to assist the slaves who had run away. And so those people then would get into legal trouble. They'd run afoul of this federal statute. So they'd bring them to trial. And fortunately, if you were fortunate enough to live in a community where there were a number of abolitionists, then they would find these people who are, again, factually guilty, they would find them not guilty. And it made the enforcement of that law much more difficult. And this, I think, is one of the great aspects of jury nullification, is when it makes a law tougher to enforce, a bad law tougher to enforce, you are much less likely to see enforcement of it by the police, and in particular by the prosecutors, because prosecutors don't like to have losing They don't like lost cases on their records. Those records now seem to be very important to them. And so um, making it hard for them to win will make it less likely that they will charge those crimes. Um, it was there was a great abolitionist, Lysander Spooner, who wrote a great article on trial by jury. And I won't really speak about that, but it's something that we have available. I believe there's probably a download of it on the website, and there's also materials that you can purchase if you wanted to have it on your shelf or distribute it, that are available through the website as well. Printed copies of his writings on trial by jury and the power of jury nullification that jurors have. So the Sander Spooner is a great name for those of us who are interested in jury nullification. Um, Advancing to the 20th century, there was you are likely familiar with the experiment in prohibition that the United States engaged in, and one of our at FIJA's favorite stories from that time period was a jury who asked to examine the evidence against the defendants. And so the bailiff, as instructed, brought in the jug of moonshine. And the jurors, being diligent fellows, I'm sure to the last man, decided, well, we can't obviously just take anybody's word for this. We have to investigate this ourselves. And so, they each took a sip and passed it around, to the point at which, at some point, there was no moonshine left in the bottle, to which they had to return that and to the court. And when they were asked what their verdict was, it of course had to be not guilty, because there was no evidence against the client, against the defendant. And the prohibition was a rather unpopular law, by many people. So you would certainly have jurisdictions where the law was basically unenforceable. People were not going to find you guilty of running afoul of that, because they thought this was an absurd law, an unjust law. Even though it was an amendment to the Constitution, they had a differing perspective on, at that point, Constitution be damned, this law is not right. And so, just as in a prior generation, as we mentioned, slavery was wholly legal federally, but people saw it as properly as a immoral practice. And so, again, you had prohibition, where it became very hard to enforce that law. And we see this echo through to today, where we see, even in some places where certain drugs are still illegal, and folks are brought up on charges. And of course, they're still, federally, they're not legalized. But folks are brought up on charges, and juries are finding them not guilty. And so it's a wonderful thing. And then kind of next, I would mention the Vietnam War era, where you had there was a very famous trial of the Camden 28. And that was there's a really terrific documentary that's available that I would encourage you to watch. It's an inspiring film, and just very fascinating historically, and particularly in its relevance to jury nullification. You pretty much had everybody. What the trial involved was a number of people who broke into a draft office and destroy a lot of the records. And they were in some ways set up and encouraged by somebody who was acting as an informant. And basically, the jury felt for, I guess, not entirely clear what rubbed them the wrong way about that action and about the charge, or about the charges, and the entire process. But they found the Camden 28, all 28 people, not guilty, despite the fact, again, that there was no dispute about the facts of the matter. So jury nullification has been a wonderful tool. and we still see it used today. Now, one of the big shifts in court practice was jury nullification was something that was rather commonly known, and a judge might explain it to jurors that they have that power. But that really changed during the antebellum period, during that slavery period, where judges really started to discourage people from having the knowledge and from practicing, from engaging in jury nullification. And we've seen that practice, even post Civil War, post Reconstruction, we've not seen that change back. So we still have a court system where judges seem to even seem to outright deny at times people's right to nullify as jurors. The very least, people aren't told, and a judge or a juror who talks about it can get removed from their from the courtroom. Um, I mentioned recently when somebody had asked me if I had been on a jury, I was aware of jury nullification at the time, but not aware of best practices in regards to being a juror. So when the court began to ask me questions, I started talking about jury nullification. I was in my early 20s. I was excited. I love the ideas. And I was asked to leave immediately. And I've yet to be called back since then. And I'm disappointed. I would love to serve on a jury, especially with what I know now and what I would do differently. And so I think now this might be a good time to turn it over to Will, as he might help give you some advice on how to not make the mistake that I did. So you will have the privilege of being able to serve your fellow man on a jury and vote your conscience.
Yeah, so first there's the question of getting on a jury. And in that case, we strongly recommend, for a variety of reasons, that you tell the truth always during juror selection process. But that doesn't mean that you have to run your mouth and give them a bunch of information they wouldn't otherwise have. A juror's should treat serving on a jury as a remarkable opportunity to save a life or to, be a part of actual uh like decision making and actual engagement and what is happening in our society and the ethics of that. That is something that is impossible for people who decide that they want to, in the jury selection process, make a big fuss and raise their arm and, give a giant impassioned speech. It typically doesn't change anyone's minds, and it typically doesn't accomplish very much. So ideally, you tell the truth, but you give simple, straightforward answers. And if you're asked questions that are leading. If they ask you about jury nullification, admit that you know about it. Oh yeah, I've heard of it. That kind of thing. If they ask you, would you in a situation be capable of, voting according to these lines or something like that, and be like, I believe that I can do justice because the whole of justice is what you're trying to pursue, not just a simple matter of fact. But answer truthfully entirely. You just don't have to give a giant political lecture. And that's not usually a very useful moment to do it. Not ragging on anyone. Lots of folks are very enthusiastic and make that mistake. But the goal is to have an impact. And with that, though, for those of us who have not been selected for jury duty, simply having this knowledge alone by ourselves doesn't really help anyone. Probably the most effective thing that you can do is communicate to other people what their rights are and how to go about getting selected on a jury or not being filtered out, and show up not super acting like you're super excited to be there, because that's actually a flag. Most judges and prosecutors do not want jurors who are excited to serve as jurors. They want people who are vaguely disinterested, etc. So, toning down your emotional responses, dressing like a normal average citizen, that kind of thing. Not coming in there with a giant pot t-shirt or something. But presenting yourself in a normal way is a very effective way to get on a jury, or far more effective. But the thing I want to convey today is about jury education itself and how to go about pamphleting or doing outreach and communicating to folks. And the number one thing I want to convey is that it's an amazing return on investment. One of the most common things you encounter outside of a courthouse or people who have already been to a jail or prison um, is that, or from people who've already been to a jail or prison, is they will convey just how broken their lives are from that experience, how devastating it was, how it transformed everything, how it weighs on them for the rest of their life. A few years inside can just completely destroy someone's life, even for a minor infraction, something where you think, oh, well, the maximum sentence isn't that much, it's just a couple years. Even that can be something that can take someone decades to recover from. It's not just a matter of the trauma and abuse that our prison system encourages and endorses as a core component of the experience, but it's a matter of severed ties with the outside world, the lost relationships, the lasting economic impact on job prospects, the loss of a house potentially, et cetera, et cetera. And the incarcerated aren't the only people left scarred by the courts. Jurors, too, often report severe despair, anger, and self-recrimination over their experience. It's common for jurors to break down sobbing after handing a guilty verdict or after sentencing, feeling like they didn't have a choice or weren't informed about what the consequences would be. I've had total strangers break down talking to me about their experiences in a jury box 10, 20 years ago. They're so racked with guilt and a sense of powerlessness. But of course, those who suffer the most are the convicted, obviously. And just 1 hour of your time can frequently save someone from years in prison. This is the great feeling of jury rights outreach. It really does work. All you need are three things. One, take 40, 80 jury rights pamphlets, either purchased on our website, fugia.org, or printed as free PDFs that we make available. Two, a sign reading jury info. Just jury info, little like polite sign because you're giving information about juries. And three, an hour free early in the day or at lunch, and ideally on a Monday. You also need to remember three core things to stay clear of trouble. One, do not bring up or talk about specific ongoing cases. I cannot emphasize that enough. Do not bring up or talk about specific ongoing cases. Two, give literature to everyone. And then three, stay back on public property and obey officers, even if their commands are unreasonable or unconstitutional or what have you. The best time to litigate that is after the moment where you're passing out information because you can make a situation worse. Um, I'm going to talk you through some of the processes so it's clear, and some best practices. And then afterwards, I'm going to go over examples of legal sanction that activists have faced and survived, and thus why we advocate the specific things that we do. First, how to distribute pamphlets at a courthouse or other public occasion, but we're mostly focusing on courthouses because that's where so many people who are involved in the justice system or thinking about jury duty oftentimes go. So first, research the location before you go. It shouldn't be a surprise when you get there that there's no place to park or that there's no there's no good place on the sidewalk. Research it first. Take a look on Google Maps. It helps to be studious too if you want to browse the courthouse website for administrative rules, for timings, browse local ordinances for anything that might apply. You can also sometimes just call in and ask, like, when are jurors expected to show up? And you don't have to say that you yourself are a juror, but if you want to like meet people before they actively serve on a jury, that can be a good opportunity if folks are being asked to come in early in the morning, that kind of thing, coming out earlier and just providing information before people are impaneled. And again, provide information to everyone. And then check in particular whether there's any standing administrative orders affecting pamphleting on the property. Judges sometimes issue administrative orders that pertain to the sort of things that we're talking about, or they may falsely claim to pertain to distributing pamphlets about jury information. And not all administrative orders are on the courthouse's website. Again, sometimes you can just call and ask. Somebody who's the secretary in there can do a good job just looking it up for you. They're not, that they're not necessarily going to give you a hard time for asking questions about what the law is. Look up your state-specific jury tampering statute. The language varies significantly. Some states require proof of intent. Others are drafted more broadly. It really depends. If you're in doubt, you can always email us. You can email us in particular at hai@fiju.org. But please give us as much advance notice as possible about the specifics you'd ask us to look up because, it takes us a while sometimes, or we just don't have the staff to be able to handle it. In terms of timing, insofar as you're able to determine, choose dates to canvass unrelated to any single trial. And that's important. Again, you want to be demonstrating that you're not targeting a specific trial in a targeted way to influence specific jurors on that. So it can help to conduct outreaches when multiple trials are underway or even when no trials are in progress. The best way to ensure that you're able to consistently canvass is to show consistently, right? In ways irrespective of any specific trial. Judges have used the visibility of celebrity trials as a pretext for sweeping restrictions on all courthouse pamphleteering in order to make that less possible for them. Make a strong case, show up every week. And if you show up every week, you can be like, well, this week is like no other, or is just like every other week. It's no different. Court business tends to peak in the morning. The busiest window is typically 8:30 to 11:30 a.m. And again, impaneled or potentially impaneled jurors arrive on Mondays. So first, find a location when you arrive that you're not blocking anyone's path, but have access to many passersbys. Then mark off the space and how you plan to move, so you're not going to stray too far. So you're not going to become too aggressive on folks. The only exceptions to handing someone a pamphlet who's coming by is if they're talking on the phone or they're giving sort of like aggressive or uninterested looks. A nice thing that I will say oftentimes is interested in your rights as a juror and just proffer a pamphlet and they can take it or they don't have to take it. Do not target jurors alone. Hand pamphlets to lawyers, defendants, cops, bystanders, what have you. Again, this proves that you're distributing information generally. And it's also the site of interesting conversations and the ability to reach potential future jurors in other situations. Speaking from experience, you will get sneered at by prosecutors, and you will get sometimes encouraging grins or comments or long happy, excited conversations from defense attorneys. Some defense attorneys, public defense attorneys, are really overworked, and even if they are, a little sus as to whether or not, they should be talking with you or whatever, they are usually pretty happy to have you doing the work. They understand how bad the system is. Again, do not discuss current cases with jurors. This is potentially a very serious crime. You could go to jail. FBI agents posing as jurors have tried to entrap jury nullification pamphleteers via this sort of thing. Simply say if somebody tries to talk to you about their trial or I'm having all these difficult thoughts or whatever they're going to say, you shouldn't talk to me about this case and I don't want to, but you can take information on your rights in general and move on. Never discuss a pending case. I'm just here to share information. I'm not involved, right? If asked by law enforcement, if you're trying to influence a specific jury, be very clear. We're conducting general education about juror rights. We're not advocating a specific position in any specific trial. And if they give you any sort of harsh thing or detain you, remain silent, contact an attorney. Be respectful. Courthouse staff and security, passersby, even the media will form impressions of the legitimacy of what you're doing within seconds, and appearing normal and conventional will assist you. Security may want to mess with you, but feel less inclined to if bystanders see you as someone less fringe, someone just completely normal and average, advocating something entirely straightforward. Do not be confrontational with security or police. If told to move, move. Only then, after you've moved, assess whether the restriction is legally valid, and you can start to evaluate the documents if they give you any documents. If you get pushback from courthouse officials threatening you, tell us about it. If you get pushback from the cops, tell us about it. Sometimes we can help you with information on that or hook you up in contact with someone. Again, AJI@fija.org. We'd love to hear from you about those experiences. Don't think that you have to be frustrated in isolation. It generally helps to have one person in addition as the friendly greeter and others to kind of help hand out pamphlets in the back. That depends. If you have like a whole host of people, you can kind of set up little clusters so that one person's with a couple of backup people right there, another person's over here with a couple of backup people. But the point is like one person to be like, hey, do you want a pamphlet? And then other folks to like, kind of come in the back. One person who leads conversation, other folks who are just there to be like happy. Um, Fellow compatriots. That actually can do a lot, and rotating roles can sometimes like give you a break if you're feeling like overexerted as the person in the front. But not having like five people suddenly be like, want a pamphlet in your face at the same time is it's effective to be more restrained in that regard. Um, and a single coordinator can help provide bottom lining. You can carry a copy of the relevant laws and administrative orders and feature contact information. And again, if something goes wrong in any which way, you can take the lead on talking to authorities or to us. Again, just handing out information on educational materials on jury rights. If possible, assign someone to document. Photos and videos of your location, your conduct, and any official interactions are valuable. A wide angle video showing that you're not blocking traffic, not approaching people aggressively, or on public sidewalk can be decisive if you get any sort of harassment or charges. And I cannot emphasize this one enough. Never bring weapons. Even legally carried ones. Whatever your views on the Second Amendment, you are trying to appear straightforwardly non-confrontational. You don't want to be intimidating anyone, and carrying a weapon, if they're already going to try to make up things about how you're intimidating jurors by passing them out a pamphlet, the last thing you want to be doing is giving them any sort of additional ammunition, so to speak, in that regard. So now I'm going to go over some specific cases because, this advice that we give you arises from specific backgrounds. So Julian Heiklin is the first example I want to cover. He was a chemist involved with the civil rights struggles of the 1960s. He was also involved in marijuana reform and all sorts of other things. After his retirement, he worked heavily on jury nullification and was arrested multiple times by federal cops while distributing feature literature at the United States District Court for the Southern District of New York. On April 19th, 2012, District Court Judge Kimball Wood granted Heineken's motion to dismiss an indictment as legally deficient, but specifically, he had been indicted for passing out information. The court ruled that prohibitions on attempting to influence a juror and communication about a specific case do not apply in the case of FIJA materials because our pamphlets are generic and make no reference to specific cases. However, what is important to know about Julian Hecklin's case is the government had deployed an undercover FBI agent who tried to get him to discuss a specific case. He refused to discuss any case in progress, but was nevertheless arrested and charged with jury tampering. His refusal to take the bait was ultimately what protected him legally. Again, like never discuss a specific pending case with anyone during outreach. If someone raises a current trial, decline to engage. Change the subject or end the conversation. I also want to talk about Mark Iniesili and Eric Brandt, who were arrested in two separate days in the summer of 2015 outside of a courthouse in Denver, Colorado. They were both falsely charged for exercising what are essentially First Amendment rights by passing out feature flyers. And they were charged with felony jury tampering. The Colorado's jury tampering statute states a person commits jury tampering with intent to influence a juror's vote, opinion, decision, or other action in the case if he attempts directly or indirectly to communicate with a juror other than as a part of the proceedings in the trial of the case. They had been offering feature literature to numerous people who had business at the courthouse that day, and government agents tracked down several people who had been called for jury duty who received the flyers. The government's stance seemed to be that anytime that any juror or potential juror had received a flyer, that constituted not only jury tampering, but specifically an additional independent account of jury tampering. The charges, however, were never addressed in trial. The case was initially dismissed in short order by the district court because the alleged behavior does not violate the jury tampering statute. The district court ruled or the district court judge ruled that they engaged in activity that's certainly no different from citizens of this country, the state, the city, holding up signs in a place where they knew the jurors would see them, signs such as, free the Chicago 7 or the 8, don't convict, and so on. And that's similar. That's speech. It's very similar to what the defendants did in this case. Activities such as these are protected by the First Amendment, so that because they are speech, they are in a public space, and that's all the court needs to, and as far as the court needs to go. The charges were again verified to be invalid by the Colorado Court of Appeals, which, argued in some we hold this section applies only to attempts to improperly influence jurors or those selected in which a jury in particular case will be chosen. Because the people didn't charge defendants with attempting to influence such a person, it follows the district court didn't err in dismissing the charge. Um, and again, these prosecutions of the prosecution of these two individuals, persisted all the way up to the Colorado Supreme Court, and the Colorado Supreme Court, again, in a majority opinion, concluded that it's a basic free speech right. For purposes of Colorado's jury tampering statute, this is what they said: a juror is any person who is either a member of a jury or a grand jury or any other person has been drawn and summoned as a prospective juror. And to commit jury tampering, a person must attempt to communicate with a juror directly or indirectly with the intent to influence that juror's vote, opinion, or otherwise in a specifically identifiable case. And because jury nullification information is not specific to an identifiable case, that doesn't actually count. And then there's Keith Wood's case. So in the 24th of November, 2015, 2 days before Thanksgiving, Keith Wood was arrested at the Mecosta County Courthouse in Michigan for sharing Fuge's Your Jury Rights, True or False brochure on a public sidewalk. While handing out brochures to any passerby who wanted one, Woods was repeatedly approached by courthouse officials, ultimately being threatened with arrest if he did not accompany them inside. Once he reluctantly went inside, the judge ordered him arrested. He was also questioned without legal representation by the prosecutor in his case. His bond was set at $150,000, and he paid $15,000 on a credit card to get out. His attorney, David Coleman, argued for it later to be reduced, and Wood's payment was actually refunded to him quite a while later. However, he was left on the hook for the substantial interest charges that piled up in the months before his payment was ultimately refunded to him. Despite there not even being a jury seated at the time he was sharing brochures, he was falsely charged with felony obstruction of justice and misdemeanor attempting to influence jurors, putting him at risk for up to 6 years of incarceration. Wood's attorney successfully argued for the felony charge to be dismissed. However, the misdemeanor charge continued. And then Wood's jury convicted him of the misdemeanor charge. The judge immediately sentenced him to 8 Friday through Sunday weekends in jail, along with other penalties. And this actually proceeded. Not only did the trial judge refuse to stay the sentence, which would entirely be served before the appellate court could even be heard, but all other judges in the Costa County Courthouse refused as well. An emergency hearing regarding the stay was upheld by video with a judge in a neighboring county. The judge in this hearing recognized that there were significant issues that could potentially prevail in an argument, granted an emergency stay, and Wood was released pending the appeal. Unfortunately, in his first appeal, the circuit court upheld the trial court, and he began serving his unjust sentence. He served 3 weekends in jail before the Michigan Court of Appeals granted his request again and again stayed the sentence. And then finally, the Michigan Supreme Court filed its opinion that the individuals who were summoned for jury duty and had not yet participated in the case were not jurors under Minnesota law. Because this case was decided on very statutory grounds, the constitutional arguments were not decided. But this is illustrative of kind of the worst way it can go, right? They can harass you and detain you and do all these things to you for a while before eventually your rights get verified. However, this is very rare. The sort of things that we're talking about are the worst sort of things that can happen to folks who are doing pamphleting. We're just bringing them up again to emphasize the way that documenting what you're doing, being clear that you're giving to everyone and not talking about specific cases, not doing anything that could be conceived of as threatening or intimidating, are so important to exercising your basic First Amendment rights. Another example is roofing contractor Mark Schmitter, who had been conducting a long-term general education campaign in Florida. When the high-profile trial of Casey Anthony began, the judge issued an onerous anti-free speech order prohibiting pamphleteering at the courthouse. He later followed up with another order defining an obscure free speech zone. Neither of these orders were uniformly enforced. Schmidler had been handing out pamphlets periodically over the course of nearly a year and was not doing anything related to the Casey Anthony trial, yet he was arrested and charged with contempt. Schmitter was not permitted to a trial by jury. Instead, he was tried by the judge whose orders he was alleged to have violated, found guilty, and sentenced to several months in jail with additional fees. He served 104 days. So Florida, particularly horrific case. And I'm going to run through some other instances pretty quickly. Luke Lamb, who is not to be confused with Mark Lamb, who is tied up with neo-Nazi activity, but Luke Lamb, who was in a campaign for the Greene County Sheriff. He was prosecuted for sharing a link to our website and for making other comments about jury nullification on Facebook. So he was literally prosecuted for a Facebook post. The individual at the time he was communicating with happened to be serving as a juror, but had not yet been assigned to a case. The sitting sheriff who was running against him noticed the social media activity and got a special prosecutor involved. Lamb was prosecuted by a jury for tampering, but he got a jury trial and was acquitted by the jury. And in 1994, a man was acquitted of obstruction of justice charges, again, distributing feature literature. The Perry County Courthouse in Pennsylvania. In 1996, a 53-year-old man was arrested for passing out feature pamphlets to prospective jurors at the Clark County, Nevada courthouse. I believe it was also dropped in his case. In 1995, a 51-year-old mother was charged with jury tampering for papering the windshields of cars near the federal courthouse with feature literature when her son was on trial and facing heavy mandatory minimum drug sentences. And that was considered to be so specifically oriented that they were able to get away with that. In June 2000, Douglas Bruce was called to appear as a potential juror for a trial in Colorado Springs. During the jury selection process, Bruce distributed feature pamphlets in support of jury nullification. What was interesting about that case was it was so disruptive that they not only dismissed Bruce, but they also dismissed 50 other potential jurors who had received the flyers, resulting in a 2-week delay for the trial. But ultimately, what we would like to accomplish is not perpetual delays of trials, but actual involvement in the process of shaping justice. So that's the list of examples of the sort of pushback and the sort of political repression and violations of free speech that folks have faced historically in recent history. And part of the reason why we give the advice that we do around trying to educate folks. I'd like to open it now up to questions if folks do have questions, and they can put them in the chat or they can use the Q&A system. But yeah, that's as much as I've got. I think you're muted, Robert.
Thank you. I was going to mention that, you know, Kirsten, former executive
Yes.
director of FIJA, and we were able to go. We both were there and attended some of the trial of Markey and Shelley and others in Colorado. FIJA unfortunately is not in a place where we can't provide any legal support for any sort of problems or things that should they occur. And it's not a likely thing, but it is certainly a possible event. But yeah, she was able to provide some support for the activity that they were doing in court there, and also obviously we were there as moral support for the folks who essentially they were free speech charges. But the wonderful thing is they had a tremendous attorney who was serving pro bono, David Lane. And these are kind of some of these actions. There are attorneys who just love these kinds of fights. Not that you want to get in trouble and test these things and acquire their services that way, but fortunately, there's a lot of people who do believe you should have the right to be able to talk about your rights as jurors and not have to face penalties. So it's so you're not necessarily alone, and we will do what we can to help as possible. But certainly, the best. Will gave a lot of tremendous advice on ways to kind of stay out of trouble, stay out of harm's way, which of course is the number one goal in your advocacy. Live to fight another day, as it were. So great advice from Will.
Yeah, so there's a question. Is there a list somewhere of all the historic jury nullification cases that were mentioned at the beginning with the great quotes that were shared? And there is.
Oh.
There's FIJA.org indexes a bunch of these things. And we also do on social media, we give some selection occasionally and republish individual cases of prominent jury nullification. For example, there was Shalom Schwarzbard situation in Europe, where a genocideer who had been responsible for the killings of a great many communities and people was himself killed by one of the survivors of that community. And the court case, or the trial, was infamously decided by the jury, decided that he was guilty, but only guilty to the penalty of 1 franc. So he had to pay the widow of the genocideer 1 single franc, and then he was off scot-free. And there's a number of other cases. There's, for example, today, or recently in the last 10 years, uh, there was uh, there was a very prominent case around an activist who was distributing water to people who were lost in the desert, who were crossing the border, and who would be, facing extreme malnutrition or extreme dehydration, and he would just leave bottles of water out in the desert and provide us, water to people who came to his doorstep. And for that, he was pretty frank about, a lot of these situations in jury nullification. The facts are oftentimes very clear, but still people will shy away from straight up admitting that they did factually the things alleged. And he was very clear that he had done what was alleged. And it was a very prominent case where, no jury was willing to convict him. There had been first a jury that was hung, and then they tried to, I think, prosecute him again, and the second jury voted to acquit entirely. So yeah, there's a lot more things like that on FIJA, we on FIJA.org. Um,
So, and I'm pretty sure that was a case down in the Tucson area, which down here we certainly have a culture where no matter who you are, you get water if you need it, because where it's the desert, and we'll reach 110 teens, 20s even, and so it would just be barbaric to deny somebody water. Um, in the Q&A, I had posted a couple of links in response to that question. One, of course, is our link, fija.org, but there's also a book by Clay Conrad, who he's an incredibly knowledgeable fellow on it, and you can download, you can purchase it from Amazon or wherever you buy your books. But there's also at the Cato website, the Cato Institute. They have a number of links where you can download it in PDF and EPUB format. So um, I would certainly suggest you avail yourselves of that. And he's got a lot. It's a slightly older book. It was written, I think, about 30 years ago, but there's a great history there, and also kind of a modern lay of the land of jury nullification as well.
Yeah, another example that I want to give before we move on is amputee and veteran Melroy Court, who took a pistol from the glove box of his car while it was in a repair shop and put it in his jacket for safekeeping. He was arrested by the police, and charged with unlawful carry and possession. Again, he was an amputee and a veteran, so he didn't really he didn't pose any active threat, and the jury just refused to convict. They were having none of it. And he was also very clear um, about that situation.
I'm going to toot Tucson's horn one probably last time today,
Uh-huh.
where we had a famous grand jury, the 269th grand jury, where they made the mistake of putting a defense attorney on there, and so they basically just tossed out case after case after case, which never happens. I mean, it's very rare, right? There's that whole phrase that you could get a grand jury to indict a ham sandwich. And of course, the recent irony where they did not indict the fellow who threw the sandwich at officers. But but yeah, that was a very unusual event, because grand juries usually just kind of, it's just essentially seeking permission to bring something to trial, which it seems okay. One could say, well, that's a reasonable activity, but it's wonderful if we can get bad cases tossed out before all of the uh, trials and tribulations. And so that's another area that I know we're looking to grow into, expand into that notion of what can we do to get grand juries to be involved, so we can head things off at the pass.
Well, in our latest pamphlet, our latest version, it's an iteration of the true and false pamphlet, but our latest pamphlets provide additional components where we talk about grand juries because this is historically something that we haven't necessarily talked about. It is usually particularly hard to get acquittals in grand juries, not just because of how they're structured around like the defense not being present, et cetera, but also the fact that like the thresholds for an indictment are very different. It depends quite dramatically on the region. But one thing that you can do if you're serving on a grand jury is ask a lot of questions because the prosecution is forced to enter their responses into the formal record, and that can actually deeply constrain them in if the case goes forward. And a defense can look back upon if you asked like sufficiently probing questions and drilled them into a lot of things, because a lot of grand juries are just like, yeah, sure, okay, ask a simple question, move along, yeah, sure, indict, 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 right? But if you actually do due diligence and you actually do your job as a grand jury, you can actually make it a much more fair situation later for a defense attorney. Um, yeah.
Any other thoughts or questions?
We're also coming up on time, so I don't,
Yeah.
I
Well,
don't want to push anyone too hard.
cool.
But thanks for coming out. Oh, thank
Yeah,
you.
thank you all, and I do would like to mention that we would love your support as well. Fija.org is a great place to go to donate, to get a tax-deductible donation. It's a 501(c)(3). What we're really looking for right now are supporting donations, ones that are kind of monthly, that would really help us to measure our expenses and where we can grow. And so just any support that you can offer is greatly appreciated. It's a very lean organization. Many of us are giving our time at over and above with no remuneration. Nobody on the board is paid. We're all happy to do it. And Will's time is extremely valuable, and we're lucky he's giving it to us at such a discount from what he's used to. So we're super grateful for that. But helping to get this information out there, we're trying as hard as we can to get these ideas out. And so your support, both in terms of money, but also in terms of time, getting out there, talking to jurors, also talking to your friends, your neighbors, going to we have some pamphlets that are designed for certain events. We've got a great gun rights pamphlet. And if that's the kind of thing you attend gun shows, hey, if you want to set up a booth and do that, we'd love to help support you with that. I keep trying to get in at my farmers market to have a table down there and talk to the folks about these ideas. So
We
thanks
also
for
have stickers and some
yeah.
posters and some other things in the store as well. So if you want to, spread information in a variety of different ways, show off your knowledge. Oh, and also thank you to the person who expressed thanks and changed their name into thanks. Appreciate it.
Thank you. Yes.
Yeah.
Thanks for your time, everyone.
Yeah.